All right. Hello, everyone. Good morning and welcome to today's webinar. My name is Julie. I'm the Marketing Communications Specialist here at Church and Casualty. And today we'll be covering California Senate Bill 2, otherwise known as SB2, which I am sure everybody has heard of by now. Our guest speaker today is Jeff Kiernan, who is our CCIA security consultant and part of our Ask Security program. So Jeff has over 30 years of experience in the field, and he helps our customers with their safety and security questions in their houses of worship. And we're super grateful to him and his expertise, and he is just a wonderful resource to us as an agency and to our customers. So please submit your questions at the bottom of your screen in the Q&A box. We'll be doing a Q&A after the presentation, so be sure to submit your questions and we'll get to as many as we can today with the time that we have. And if you missed anything today, don't worry, we will be recording today's webinar, so you can always refer to it at a later date, and we will be covering a lot of information. And if you want to share it with your team as well, there'll be an opportunity to view the presentation afterwards. So the webinar will be recorded. So with that, I will go ahead and pass it over to Jeff.
Good morning, Julie, and good morning, everyone. Thank you for joining this webinar. I'll do my best to answer your questions. And I've limited the slides to 19 slides so that we have time after for the Q&A. Okay, let's get started. We'll go over the overview of California Senate Bill 2, and then I want to talk a little bit about concealed carry weapons or license to carry inside your house of worship. I have received some questions in regards to armed security, so I'll address that as well. And then some risk management recommendations that I can share with you to keep you safe for risk and liability reasons. And then any questions and answers at the end of the webinar, I'd be happy to help you with. Okay, so Senate Bill 2, I think most of you are familiar with it. The key indicators in this bill that affects the houses of worship is identified as what they're calling sensitive places that are provisions of Senate Bill 2. And the three locations that directly affect your houses of worship would be daycares, child care facilities, your houses of worship, and any public areas that are 1,000 feet from a private school. So that's what I wanted to talk a little bit about, and then about the actual use of firearms on your property. There is an exception for the sensitive sites, and they did exclude a place of worship or private business that you may choose to allow people to carry firearms. It's your choice. If you do not want them carrying firearms on your property, that is also your choice. So again, it is your choice. Unless the operator and this is text right from the legislation that I copied for you. Unless the operator of the place of worship clearly and conspicuously posts a sign at the entrance of the building or on the premises indicating that license holders are permitted to carry firearms, it does not have to be at the entrance. So this right here is what they're asking you to do. If Senate Bill 2 passes, which right now it's on hold as of January 6th, it was put on hold, and they are having a meeting in April to discuss this to see if this will go forward or not. But as of today, it is on hold. However, if it does pass, what they're asking you to do is place a notice or a sign indicating that lawful concealed carry is allowed on your property, and to list the penal code section, which is 26-230. Or if you do not want firearms on your property, you can list a notice that no lawful concealed carry is allowed on your property without written permission of the owner. Okay. And I did make some signs for you to see, so you don't have to think of what that would look like. They do want you to state the actual word notice, and they gave specific instructions on how the sign should look. They want it in block letters. They want the word notice. They want contrasting white with a red background. And this is what it would look like right here. So that is if you do allow firearms, this is the notice that the state is requiring for you to post and to also cite the penal code section, which I have on the bottom there. It's almost like a no trespassing sign. You have to cite the penal code section for no trespassing. I have had some organizations reach out to me stating that they do not want firearms on their property. That's fine. It's not required. You do not have to post a sign. But if you feel compelled or you want to convey that message, you also can post a sign, and this sign would look like that with the word no in front of it. No lawful carry, conceal, allowed on my property, because it's your private property. So I hope that makes sense and that's clear. In regards to that, if you have any other specific questions on the notice signs, we can talk a little bit about that at the end. Now, in regard to having firearms in houses of worship, there used to be what was called an open carry, and that's when you actually carry a firearm on your hip or on your holster where everybody can see that. That is no longer authorized in the state of California. There is a penal code section there that I cited, 26350, that you are no longer authorized to carry that. So if somebody does show up to your facility with an open carry, you can simply ask them to put that in their trunk of their vehicle, lock it up, but it's not authorized on your property. Or you can call law enforcement to assist you with that if you feel that that's the appropriate thing to do. Concealed carry. There's a lot of people who have concealed carry permits. That's okay as long as you have a license and you're in compliance with the state law. Off-duty or retired peace officers also are authorized to carry concealed weapons, and private citizens with a license can also carry concealed weapons. So there are many folks that meet that category that may be showing up on a weekend during one of your services that may have a concealed weapon that you may or may not know about, depending on how large your congregation is. Other folks who are authorized to carry firearms are security officers that are actually working for a security company. They would be required to have a guard card and a firearms provision through the Bureau of Security and Investigative Services, also known as BSIS. They would work under a licensed private patrol operator or a licensed security company. So that would be if you had a contract with a vendor and you hired a security guard to provide security services for your facility or your property, that a security guard would be authorized. And the same goes for a law enforcement officer, whether it's a police or sheriff. Some organizations will reach out to the local agencies and they'll hire them for part-time work to provide contracted security at your facility. So those are the categories that you would likely see in regards to firearms. In regards to concealed carry, there has been some questions regarding what if you have a retired law enforcement officer. There's HR 218 allows retired law enforcement officers to carry a concealed weapon in any of the 50 states in the United States. The only thing that they need to do is qualify once a year if they're not a state resident, or once every, I think it's 3 years for an in-state resident, depending on where they retired from. And I'll use myself as an example. I'm retired law enforcement, so once a year I qualify and I maintain my CCW license. I can carry that in any 50 states, so they would qualify. And then if you are a citizen or civilian concealed weapon holder, then you must possess on your person a state-issued photo ID card and a state-issued concealed firearms permit. And that goes the same for me and all other retired law enforcement officers. I'm also required to do that. And you must have a working knowledge of the applicable state laws governing the ownership, possession, transportation, and use of that firearm for the state, if you're in California, for example, or Nevada. It's all pretty self-explanatory. Most of these CCW holders already know this, but I'm just sharing this with you in case you didn't know. There is a self-defense and protection clause in each state. California has one as well. And you do have the right to stand your ground and defend yourself and others without retreating. And under California's self-defense law, you act, and as long as you act in a lawful self-defense or defense of others, but you have to meet certain standards. You have to have reasonable belief that you or another person are in imminent danger of being harmed. You reasonably believe that the immediate use of force is necessary to defend against that danger, and you use no more force than is reasonably necessary to defend against that danger. So once the threat has stopped, then you would stop using force. The reasonable fear of imminent peril must be immediate and present. You are entitled to use only that amount of force that is reasonable person would believe is necessary in the same situation. So you will be held to a standard of what another reasonable person would believe if they're in that situation. And that would go for, I've had a lot of questions, if you're a CCW carrier and somebody armed shows up to hurt people, can they act? And if they feel like they fall into one of these categories, absolutely you can. Now, if you're a security guard, you must possess on your person your state-issued photo ID card and a valid concealed firearms permit, if applicable, if they have that. You must have working knowledge of the applicable state laws governing the ownership, possession, and use of a firearm. And you have to have a guard card with BSIS, a firearms provision if you're carrying a firearm, and you must work underneath a licensed security company. So that would be for a security guard. So a lot of houses of worship have asked, well, what if we continue to use armed staff? How does that affect us? Well, the way the state looks at it with their legislation, and most of this is through the Business and Professions Code, that if you are an employee of an organization, then you would fall under the Business and Professions Codes, and they would require you and want you to have a guard card, a firearms provision, and work underneath a PPO or a qualified manager. And that has a lot to do with licensing and insurance, and also minimum training requirements that the state has for security guards. Most of you folks that are on this webinar right now would probably not qualify under this because my understanding is you're using volunteers and you're not using employees. But if you do have an employee and they're assigned in a role of security and they are armed, then you would fall under this category here, and you would be required to make sure they have a guard card and a firearms endorsement, and they're under a licensed PPO. So then I looked up, well, what is the definition of a security guard per the state of California? So under Business and Profession Code 7582.1, they define a security guard as an employee of a private patrol operator, which is a security company, or an employee of a lawful business or public agency who is not exempted under Section 7582.2. Okay, so the next question would be, well, what is 7582.2, and do we fall under that exemption? So 7582 states that no person shall engage in a business regulated by this chapter, act or assume to act as or represent him or herself to be a licensee unless he or she is licensed under this chapter. Okay, so a licensee would be somebody who is required to have a guard card and a firearms endorsement and work under a security company. However, point 2 of this section, this chapter does not apply to charitable organizations or nonprofits, which most of you would be. So therefore, if you're using a volunteer and not an employee and you're a nonprofit organization, this chapter does not apply. So I know it's super confusing with the state of California and all the legislation. I had 13 pages of codes I had to go through, and I've talked to several people to make sure we understood this. And I'm trying to distill it down to just a couple of codes that pertain to what you're doing, and so that I can bring some clarification and help to explain this to you better. There's a penal code section 626.9 and 629.10. And that is regarding the California Gun-Free School Zone Act. So the statute prohibits you from possessing a gun on or near school grounds. within 1,000 feet of a public or private school. They define these schools as a K through 12. So this does not cover daycare or nurseries, but the point 10 section below does cover private and public universities or colleges. If you are a law enforcement officer, a hired security guard, or a retired law enforcement officer, then you are exempted from this. You can carry a concealed weapon at schools. There's an exemption for them. So hopefully that brings a little clarity to it. So what does CCIA recommend for risk management? Well, if you get online, if you log on to the website, there's a lot of resources there that are available to you. So I pulled some of this data here to share. And there is a Church Mutual Armed Intruder Planning Checklist that you can go through. There's a risk control security assessment checklist just to do a vulnerability assessment of your facility and your property. There's a risk control armed versus unarmed pamphlet that's provided for you. You can get that in PDF form or in hard copy. There's also an emergency response, or I'm sorry, there's not an emergency response plan, but it's recommended that you have an emergency response plan or an emergency operations plan or a policy and or procedure manual for your staff and volunteers. The policy would be the why we do things, and that would be based off of state mandates and compliance. And the procedure would be how we do things, how to do our job, especially for your staff and volunteers who are showing up to help. You want to teach them the job description of what they're doing, whether it's a parking lot person or a door greeter, or if you have a safety or a medical role or a security type role, that would benefit them greatly, so they understand the parameters of what their expectations are and what you don't want them to do. And then to conduct drills or tabletop exercises, and you could do a walkthrough, you could talk about it in a conference room, you could do a practice exercise outside using your volunteers or your congregation members, or work with your local first responder community and have them come out and do a walkthrough with you. Those are all options to consider. And then create a training plan, and then document your training. I've talked to a lot of houses of worship that train, but they're not really good at documenting. If it's not documented, then it's hard to prove that you did it if you're questioned later. Plus, you want to hold your folks to a standard, and you want to hold them accountable, and that could also be in part of your documentation. And then have a medical emergency plan. The majority of medical emergencies are probably going to be some type of shortness of breath or diabetes where they need insulin or sugar, or it may be the need for an AED if someone's having a heart attack. You could have a trip and fall or a bleeding incident, but also you want to look at hemorrhage control for mass bleeding and how to apply a tourniquet and stop the bleed. So those are other things for you to consider to have. Then the question, of course, comes is, if I have a security member with a CCW versus a non-security attender with a CCW. So basically what that means is, if there's somebody in your congregation that's a concealed weapon carrier, they have a permit, they're legal, and they show up and they're just in attendance, right? They're not part of the team, they're not part of the church, they're just there. And then you have an incident that requires an armed confrontation. Say you had like an active shooter type scenario, and you have that person gets up and addresses the threat, uses his firearm, and saves the day, right? And the person's the hero for the day. The question is that person covered? And the answer would be, if he's not part of your organization and he's not part of a team that's documented, that's falling under the criteria that we just went over on the previous page, then he would just be a citizen that's acting on his own behalf for his own safety, and he would need his own insurance to cover himself. And then if you have a person that is part of your organization that is training with your organization that does have a policy and procedure manual or emergency response plan, and they're documenting that training, and you've vetted that through your organization and provided that to your insurance company, then that person would be looked upon as a member of your organization. And Travis, is this where did you want to jump in on this or?
Yeah.
Okay.
Thanks, Jeff.
Sorry.
No problem. Am I on? I'm on. Okay, great. Hi, guys. Travis Chuck. I'm a Church and Casualty. Insurance, I'm going to give you the lawyer answer. I'm not a lawyer, but it depends on the circumstances when it comes to insurance. But a couple things, as Jeff pointed out, the insurance carrier really wants you to focus on training, which Jeff talked about, and documentation for your security team, because it's extremely important that insurance follows people under your direction of the named insured. So if they're under your direction, if they're part of your security team, they're part of your insurance plan. Now, and if they're not part of the security team, then they're really not under the direction of the house of worship. So that's one thing. The other thing is insurance typically excludes coverage for criminal or intentional acts. So it's not going to cover criminal acts and it's not going to cover intentional acts. However, for intentional acts, if you're using reasonable force to protect persons or property, there is protection, there is coverage. So your security team is protected, acting under your direction. But one of the things the carrier out there is going to want to see is what's your training in place, what do you have in place to make sure that you're adequately running a security team. And I'll give a little brief highlight. Jeff is actually, we're working in cohesion together sorry, Jeff, if that's okay, I could let this out of the bag a little bit. But Jeff is working on basically a security plan template that most churches can take and then implement and obviously refine to their organization, their house of worship. But Jeff is working on a security template that we're partnering with, and look forward to keep on the lookout for an announcement regarding that pretty soon. All right. Back to you, Jeff. Thank you.
Okay. Other insurance coverage options. I think this is important to consider. So if you're a police officer and you're at church and a felony happens in your presence, they can act upon that as an active police officer or peace officer and make an arrest and take them to jail, testify in court, write the report, do all that. That scenario, they would most likely be covered by their agency because they're acting on behalf, if that makes sense. However, if you're a peace officer, active duty police officer, and you're working like a side job, and you're in a security role, and something happens and they take action, the agency most likely would not cover them because they're working outside the scope of their work and the scope of their job description as a police officer. Now they're working under somebody else's role, so that somebody else's role would have to cover them. I'll use myself as an example. When I was working as a deputy sheriff, I used to work the Monday Night Football games at Candlestick Park for 49ers. And so I was security. If anything happened there, I was not covered. I would have to be covered under the security company who I was working for. So that's for the active duty law enforcement. If you're retired law enforcement, one thing that recently that was changed was under the pension reform, that if you're a retired peace officer in the state of California and you commit a felony, you automatically lose your retirement benefit. In other words, you lose your pension. So that's one thing that, if you're acting on behalf, make sure that you're doing it within the parameters of the law, because if you do get charged with a felony for whatever reason, whether it's carrying the magazine capacities now are only 10, if they had a leftover magazine from when they were working and now they have a 15 round magazine, I hope that's still a misdemeanor, but it's a wobbler now, I think. So, silly things like that, you gotta keep in mind. And then the last thing is personal CCW insurance. I would strongly recommend that if you are carrying a concealed weapon, that you have your own individual insurance. There are companies out there that provide this. I personally, I have my own insurance. There's another company that provides specific house of worship volunteer coverage policy just for people who are in this capacity as volunteers who are armed. They'll cover you. And I would strongly recommend you have that for yourself and for your family, and not rely on other sources to protect you. So it's always beneficial to have that. And I think that's it. So I wanted to spend a lot of time for Q&A because I know you guys are going to have a lot, and I'd love to answer your questions.
All right. Thank you, Jeff. All right, let's just hop right in. So first question, I am an ordained full-time pastor. I do not have a CCW permit. Can I carry or keep a weapon on the church private property if the elder board specifically allows it?
Okay, you're a minister with no CCW permit, but you want to carry a gun while you're on the property. Good question. If it's a private property and you are an agent, if you're an owner of the private property or an agent on behalf of the private property, as long as you are inside the private property and do not leave, you should be okay. And I'll give you an example. There used to be a bar. There's a strip club in Redwood City that we had problems with when I was on night shift, and the owner had a gun, and he was okay to have it inside, but the second he stepped outside on the sidewalk, we could arrest him. So you just have to understand what your parameters are. I would strongly encourage you to get a CCW and get the license, and then get insurance for that. I think that not having that, you're putting yourself at risk for liability.
All right. Next question. If we post such a notice, does that allow private citizens who have a license who attend our places of worship to carry their firearms?
If you post a notice that allows firearms, then yes, then people see that they're okay to carry their CCWs inside. If you post a notice that says no, then you're telling the public that you don't want guns on your property. It's a private property, and they're not authorized. Some churches, let me just add one thing, Julie, sorry, but some churches are actually adding to that. They're saying that no firearms are allowed unless with specific permission or authorized by the house of worship, which means their security people are allowed to have it, but nobody else is. So that's what other churches or houses of worship are doing. So as long as you follow the law and you post that sign and you post that penal code section, that's what the state is asking you to do so that you fall within compliance.
Okay, great. Okay, let's go to this one. A minister paid by the church with a CCW would not be able to participate as part of the church security team unless they have a guard card? Question.
Yeah, that's a tough one because the legislation is specifically written for employer-employee relationships. And I think his role would be a minister. His role is not security. If he was acting in the role of security and he was being compensated and paid, and he has workers' comp and all the other stuff that comes with it, then he would fall into that category. He would be required to get the guard card and everything. If that makes sense.
Okay. All right. If a church doesn't post any signs regarding SB2, is there a penalty?
Yes, it's I think it's a misdemeanor, and they'll definitely they'll. I don't know if they're going to monitor it. I mean, that'd be tough for them to enforce unless somebody reported you. That's probably how it would happen, is somebody would report you, and each city, jurisdiction, or county would manage it differently, I would think. But yeah, there's a penalty for a penal code violation. I'm guessing it would be a citation and a fine.
Okay. All right. So just to be clear, the law is stayed and not in effect right now, correct?
Yes, it was stayed on January 6th. They're supposed to revisit this sometime in April. And we will find out in April if there are any changes or if this is going to be completely stayed. You know, a lot of people are saying it's unconstitutional. They don't think it's going to go anywhere, but we thought that about the marijuana laws in the 90s. So we'll have to wait and see what they do in April.
Sounds good. What happens if our church allows CCW, but other businesses that share our parking lot do not?
Well, are you talking about like for Saturday or Sunday weekend services at the church? You allow the CCWs, other people who share your parking lot do not. Well, then they won't. I mean, you can't go to their. Is it in the same building, or is it like a strip mall and there's other businesses in the strip mall? Then that's separate, right? But I would think you're good. You can still allow, if you want them to have firearms and you're authorizing it, then you're good. I don't understand who the other businesses are or where they're located, but hopefully I was able to answer your question. I'm not sure.
Okay, can you elaborate a little bit more on where the signs should or have to be posted?
I think it's on the front entrance, the door, the wall next to the door. Where you have, if you have other signs that are already on your property, you can put it right with those signs as well. I think it just said, and I can go back to that screen because I looked at the actual text. It actually says right here when creating the sign. It doesn't say specifically where it goes now. It just says on your property. Conspicuously post the sign at the entrance of the building or on the premises indicating that license holders are permitted to carry firearms. So at the entrance of your building or on the premises. So I think wherever you think is most appropriate, as long as it's clearly seen and visible. I just went to a mosque last week, and they had a sign on the front entrance of the parking lot up against a tree. There's a big sign. You couldn't miss it where you're walking when you drive in, but that's where they posted theirs. So I think it'd be a judgment call for you.
Okay. Sounds good. Okay, so seeing as how SB2 is on hold, are we still required to post the signs?
No, you are not. If you want to be safe or get ahead of it, you're welcome to do that. If you don't, then you don't have to.
Okay, great. Okay, let's see. You have to post if it's allowed and you don't have to post if it's not, or do you have to post either way?
No, only if it's allowed, you have to post. If you do not have to post if it's not allowed, but you can post. Some people want to post that it's not allowed. So and if you do post it's not allowed, it's the same sign, you just put no in front of it. And those are the examples that I provided. I can skip back over to those to show you. So this one is yes, you can have a gun. And this one here is no, you cannot have a firearm on your property. So you don't have to, it's not required, it's not mandated, it's your choice. All right. But this one is mandated if it passes.
Gotcha. Okay, great. We have 3 entrance doors and 2 parking lots. Are we required to post at all doors?
It did not specify that you had to post on all doors. I think it would be prudent if it's an ingress for people to enter your building, that you want to provide them with that communication, because they could say there was no sign and you can't hold them to it. So it's probably smart to put it on the entry doors.
Okay, great. Let's see. Just scrolling down here. We may have answered this one, but if a pastor has a CCW and carries and is part of the security team, does he need a guard card?
Well, if he's on the payroll, then according to the state, they would say yes. I personally, I'm not a fan of that. I think that's not a bad idea. But if he can have a CCW and he just don't be on a security team. He's a pastor, right? He's a leadership role. If something bad happened and he had to act to defend himself or others, then he's doing that as a private citizen. CCW carrier, he's not part of a formal security team. So he would be okay there in that situation. But if he calls himself a security team role and capacity and he's an employee, then he would fall under that business and profession code that wants him to have the licensing. Does that make sense? Same with the minister that asked earlier, first question.
Okay. Our 90-acre church campus in LA County consists of a church, a college, a K-12, and preschool. Would the 1,000-foot no-gun zone apply on the property for staff and volunteers that are certified CCW holders?
The letter of the law, they want 1,000 feet. So that's the how it's written. If you have a worship service on the weekends and school is not in session, and it's your property, and you want to allow your concealed carriers to carry, there's nothing specific that says you cannot. That was not thought of or legislated, so it's kind of in a gray area. I would consult with your local law enforcement and ask them what their understanding of that penal code section is, and if that's something that they would consider enforcing or not. But I would not want to tell you not to. But the way the legislation is written, it says 1,000 feet. It does not say 7 days a week, 365. It just simply says that. So there's a lot of gray areas in these laws that have not been litigated yet. So I think you just check with your local law enforcement, ask them if that's something that they would enforce, and go with what they would tell you.
Okay, good. Yeah, this one is a little bit similar and maybe about the same question, but if a K-12 school shares a campus with a church, is the church required to follow the law for K-12 private schools while students are on campus or houses of worship?
Yeah, that would fall into that penal code section 626. If it's a school K through 12, no firearms allowed unless you're a security or law enforcement or retired law enforcement with a CCW license.
Okay. Okay, let's go to this question. I am an employee of the church and I have a CCW. I have my own insurance. My role is not security. Should there be an incident, is church in any way liable?
You're as a CCW carrier, you're not part of a security team. You're good. You have your own insurance, you're licensed, so you're good. You can show up to church every day, and as a citizen, if something happened and you acted and to save a life, you're not part of the church organization. So then the church, you would not fall under their policy, their insurance coverage, if that makes sense, because you're not part of their group. You're a member. Does that make sense? Did I answer the question, or did I miss something?
I think that's good. We'll see if anything else comes through. Let's see. I'm trying to go through these. Okay. Can our house of worship have a volunteer security team that includes CCW that carry while on volunteer security duty? Does that make sense?
Yeah, that's what a lot of houses of worship are doing right now. They have a safety and security team. So that's what we're doing right now. The legislation does not specifically call out volunteers. It only discusses an employer-employee relationship. So that 7582.2 section that exempts us, I would fall back on that until they write new legislation. None of this has been litigated. It's a complete gray area. I've had arguments on both sides saying that if we should or shouldn't. One thing to consider is some houses of worship have considered changing the term security and just calling them a volunteer. And you can wear a name tag that says you're a volunteer. Some are calling them greeters. Some are calling them ambassadors, just part of the team. Some are calling them a safety team or a safety and security team. So that because your role as security is very, very limited, but in reality, you will be doing more than security. You will be doing safety. But you don't want to, some don't like the word safety because they're not checking for potholes in the parking lot. But we are providing maybe medical aid and making sure that's a safe ingress and egress and a safe place to evacuate and things like that. So a lot of it comes down to the term that you choose to use. But to answer your question, if you are a licensed CCW carrier in compliance with state law, and you continue to qualify and you keep your records, and you're part of an organized volunteer safety and security team with your house of worship, and you're following a policy or an emergency response plan that's been adopted through your organization, you're training to the plan and you're documenting that training, and you're following everything that CCIA and Church Mutual is recommending that you follow, then you should be okay with coverage and within legislation.
All right. We have other nonprofits that meet on our campus. If we allow these groups to conceal and carry and something happens, would their liability insurance be in effect, or would it be on our insurance?
If it's another nonprofit that has a different EIN number, a different business that's not part of your business, then they would have to have the responsibility, risk, and liability to manage their business and their employees. I don't think it'd be fair to you to be responsible for their employees. And I don't know if the insurance company would recognize them under their policy either, unless you've already submitted that information to the insurance company.
All right. We have a sign saying no weapons permitted on the premise of our church. Do we need to list a penal code, and which one would apply here? So they already have a sign.
Yeah, that's great. You have a sign, but now California wants you to put the sign that they made up, which is the big notice with the red background and the white letters, and to cite the penal code section 26230 on the bottom. So that sign that's on my PowerPoint, that's the one. I believe Julie's probably going to show you one. That's the one that the state of California is requiring for you to post if Senate Bill 2 passes, which it has not. But regardless of Senate Bill 2, if you want to put it up, that's the one that they're asking you to put up.
Yeah, and we can provide a link to this sign if you would like to purchase one. This one is like an aluminum sign, so we can provide this when we send out the recording, some links to these as well. Okay, let's see here. Can we allow CCW for our church, but not other groups who meet at our church?
Are the other groups who meet at your church, are they under a contract with you, like a lease? If you're leasing it out to another organization, then you have no responsibility over them. That would be in the contract. If you're having if you're hosting like a youth group or marriage counseling or Alcoholics Anonymous or whatever you have going on, and it's one of the resources that you offer as an organization, that's your decision. That's your decision how you're going to provide safety and security for those groups. If they fall under you, it's your decision. If it's not under you, it should go on. It should be listed in the contract. And if you don't want them carrying a gun, then you put that in the contract or a firearm.
All right, sounds good. Can you elaborate on, so we have the sign, but then we were told about like certain dimensions. Does that still apply? Can we talk about like how big the sign has to be, or any minimum requirements on that?
Well, initially they said like 4 by 6 inches. Then they came up with this notice word to be centered at the top of the sign in capital letters with the color coding of the red background and the white letters. There's not a lot of the state really is not very helpful. They come up with these laws and they don't really tell you much about them. I think that the one that Julie has, what size is that when we talked about ordering those? Is that like an 8.5 by 11?
Yeah, I think so. No, this is like
A little smaller?
yeah, I'm not exactly sure the dimensions on this one, but it's definitely bigger than a 4x6, but it's not as big as like an 8x11. So
The
it's like a square size.
Yeah, let's see here. All right, I did get a message here. The exemption draws no distinction between employees or volunteers. So, which is true. That's under the exemption. It says nonprofit. So nonprofits are exempt. If you're falling under a nonprofit, you're exempt. So back to the pastor and the minister's question, you're part of a nonprofit, therefore you should be exempt under that business and profession code that I cited, and I'll bring it up. Can you still see my screen?
Yes.
Is it still showing?
Mm-hmm. Yep, we can see it.
So, right, 7582.2, bottom of the screen. This chapter does not apply to the following, and that is a philanthropic society or a nonprofit. So that would be you guys. And again, this is still considered none of this has ever been litigated, so we follow the text of the legislation, and that's what it says. So that's what I would refer you back to.
Okay, sounds good. Okay, I think we're just gonna go one more question for today. And then we will close the Q&A. Let's see. I think there's a lot of repeat questions, so I'm just trying to go through. I am an ordained minister in charge of our safety security team. I have a CCW, guard card, BSIS, firearms permit, and I cannot carry openly without being under a private company.
Okay. So that was more of a statement, wasn't it?
It was a question mark at the end.
Okay.
Yeah.
So he has a CCW, he has a guard card, and he cannot carry openly unless he's working for a company. Is that correct? Is that what he said?
Yeah, under a private company. Let's see if I can find the question again.
Now, why would he want to carry openly if he's not working for a security company? You can't. It's that there's no open carry law unless you're employed as a security guard. If that's what he's doing, then he can with a guard card and a firearms endorsement. But that's what he's doing? Or is that what he's not doing?
Yeah, I was trying to find the original question, but I don't think I can find it, unfortunately.
Well, there's no open carry allowed in the state of California unless you're a security guard in a uniform and you're working for a security company on a security assignment. Once you're off duty, then you no longer carry that gun open, if that makes sense. So that's when you can carry it, or if you're a police officer. Otherwise, you go back to the CCW laws, and if you have a concealed weapon, you carry concealed, not open carry.
Okay. Yeah, I think that answers the question.
Okay.
Okay. All right. Well, I think that is going to be all for the Q&A today. And thank you, everybody, for coming. And we appreciate your time, Jeff. And we will be sending the recording and the resources after. So thank you very much for attending today, and we will see you next time. Thanks, Jeff.
Thanks. Hopefully I was able to help a little bit. This is kind of a confusing subject.
Absolutely. Well, we will talk soon.
Take care.
Thank you. Bye.